Nnamdi Kanu will flee Nigeria, evade justice if appeal court judgment stands. Nigerian government tells Supreme Court. The government claims was contained in its appeal with 7 grounds filed against the October 13 Court of Appeal judgment which favors Nnamdi Kanu, the IPOB leader. Hello everyone, you are welcome back to Prospect Channel TV. Thank you for this coming out here. Please do not forget to subscribe to this channel if you have not. Thank you very much once again. May God bless you all. The Nigerian government has told the Supreme Court that the leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, will flee from the country and evade justice if the judgment of the Court of Appeal is upheld. The government claim was contained in its appeal with 7 grounds filed against the October 13th Court of Appeal judgment which favors Kanu. The appeal court held that the IPOB leader's rendition from Kenya in June 2021 by the Nigerian government was illegal and that the Federal High Court lacks jurisdiction to try Kanu, hence he was discharged and acquitted. In a notice of appeal dated October 18, 2022, the government asked the Supreme Court to set aside the judgment of the Court of Appeal and restore the charges against the separatist leader. According to the notice quoted by the Punch, the government is also seeking to stay of execution of the judgment of court presided over by Justice Judgement pending the hearing and the final determination of its appeal. If noted that the IPOB leader posed a flight risk. It's noted, I beg your pardon, that the IPOB leader posed a flight risk. Love Me Udobo of the Department of Public Prosecutions, the Federal Ministry of Justice, in an affidavit deposed that Kanu has a history of jumping bail and therefore it may be difficult to hold him down in Nigeria if the appellate court ruling is upheld, especially with the fact that he possesses dual citizenship as a Nigerian and a Briton. The affidavit reads that the respondent is a flight risk person given his previous antecedent of jumping bail while standing trial. The respondent is a dual citizen of both Nigeria and Britain, which will make it easy for him to move out of Nigeria and escape justice. That the respondent's presence will be difficult to secure should the judgment of the court below is not overturned and set aside by the Supreme Court. There is a need to stay the execution of the judgment of this honorable court to avoid a situation where the judgment of the Supreme Court will be overreached and rendered nugatory. Further in its appeal, the government urged that the appeal court held in law when it held that the trial court had no jurisdiction to try Nnamdi Kanu because of the extraordinary rendition of the respondent. There was no evidence laid by the respondent before the court of the first instance and indeed before the court below to show how he was allegedly adopted and rendered to Nigeria as required by Section 139 of the Evidence Act 2011, since he alleged that he was adopted without following due processes of law. Also, the appellant contend that the appellate court held when it held that the executive arm must not be allowed to benefit from the abduction of the respondent. It noted that, in fact, and by its judgment, the respondent, Kanu, was allowed to benefit from his illegality of disobeying the orders of the court when he jumped bail and was rewarded with a discharge from the charges pending against him at the trial court, thereby occasioning a miscarriage of justice against the state and the victims of the crimes perpetrated by the respondents. He told the Appeals Court that the Court of Appeal was wrong by ruling that how Kanu was renditioned from Kenya can vitiate and indeed weaken the criminal charges of treason, treasonable and felony, and terrorism brought against him, adding that the lower court made that decision without taking into account the fact that the nature of the entry of the respondent is not relevant in the determination of the charges against him. The government also urged that the appellate court justice failed to be bound by established judiciary precedent on the mode of entry of defendants charged with the commission of an offense established by the Supreme Court. The appellate insisted that the Court of Appeal misdirected itself when it relied heavily on the Organization of African Union's conventions on the prevention and combating of terrorism, the African Commission on Human and People's Rights, and cases decided from foreign jurisdictions as against the substantive law covering the criminal procedure in Nigeria. The appeal court stated that the appeal court overlooked the submissions of the appellates with regards to the ACJA 2015, which takes its taproot from the Grand Norms, Section 36 of the Constitution of the Federal Republic of Nigeria, 1999 as amended, to the effect that it is the administration of Criminal Justice Act 2015 that governs the trial of every Nigerian charged with the commission of a crime. This failure occasioned the miscarriage of justice. It also urged that the appeal court erred in law when it discharged the respondent of the offenses mentioned in count 1, count 2, 3, 4, 5, 8, and 15, bordering on terrorism offenses contained in the amended charge dated January 14, 2022, and retained by the trial court for worth of jurisdiction. The appellant noted that the Court of Appeal was completely silent on the obvious facts of the issues, which predates the rendition of the respondent because he was standing trial for conspiracy and treasonable felony terrorism before his escape. If the learned justice of the Court of Appeal had taken into consideration the fact of legality of the respondent in jumping bail and the corresponding duty of the appellant to ensure his presence in court, the decision of the court would have been different, he said. So guys, you've all heard it now. I'm dropping it here. Kindly share your thoughts below the comment section. Thank you.